The confirmation of charges hearing in the first Kenya case, the case of the prosecutor versus William Samoei Ruto, Henry Kiprono Kosgey, and Joshua Arap Sang in The Hague is scheduled to start on Thursday, 1st of September, and last until 12 September 2011. The hearings will be held before the pre-trial Chamber 2 of the International Criminal Court. This chamber is composed of Judge Ekaterina Trendafilova, presiding judge, Judge Hans-Peter Kaul, and Judge Kuno Terfusser. William Samoei Ruto and Henry Kiprono Kosgey are allegedly criminally responsible as indirect co-perpetrators for the crimes against humanity of murder, forcible transfer of population, and persecution. Joshua Arap Sang has allegedly otherwise contributed to the commission of these crimes against humanity, allegedly committed in Kenya in the context of the 2007-2008 post-election violence. We talked to the legal officers of the pre-trial chamber about the proceedings, the role of the parties and the participants, and what the possible outcomes could be of the confirmation of charges hearing.
The confirmation of charges hearing is the final stage in the pre-trial judicial process. It is an intermediate stage. It's not a trial per se. The chamber at the end of this process decides whether to confirm the charges presented by the prosecutor and determines whether the cases deserves to go to trial or not. Of course, this is done based on an evaluation and examination of the evidence presented by the prosecutor and the evidence presented by the defense. After litigation by the parties during the hearing, the chamber makes such a final determination. But one has to bear in mind that this is not a full trial, as I mentioned before, which means that at the end of the day, the chamber is not going to determine the innocence or guilt of the person. Rather than the chamber will decide whether the person deserves to be committed to trial. And the guilt and innocence question will be determined at a later stage before the trial chamber.
During the confirmation of charges hearing, the prosecutor will present the charges against the suspects, and he will present also evidence. The suspects will have the right to object to the charges, to present evidence of their own, and to challenge the evidence of the prosecutor. Victims who have been admitted to participate in the confirmation of charges hearing will have the opportunity to present their views and concerns if their interests are affected. And after the end of the confirmation of charges hearing, the chamber will deliberate and after 60 days will issue a decision in which it will decide whether or not to confirm the charges as presented by the prosecutor.
The chamber admitted 327 victims out of a total number of 394 applicants to participate in the case versus Mr. Ruto, Mr. Kosgey, and Mr. Sang, and 233 victims out of 249 applicants in the case against Mr. Mutaura, Mr. Kenyatta, and Mr. Ali. People whose applications for participation as victims have been rejected by the chamber because they do not fulfill the requisite criteria may file a new application for participation later in the proceedings, so at the trial stage, of course, should the charges be confirmed. And the same holds true for the other victims who have not applied for participation at the confirmation of charges hearing. So the victims can exercise their rights during the confirmation hearing through a common legal representative, so through a lawyer that represents them throughout the proceedings. The legal representative has been granted by the chamber the right at first to attend the confirmation hearing, so to be present in the courtroom during public sessions of the confirmation hearing. During the confirmation hearing, they can make brief opening and closing statements. They can have access to public documents, including public evidence and public transcripts, and they can also be authorized by the chamber to question witnesses or to make submissions on issues of law and fact. A victim can also be a witness, so in that case it will bear both status in the proceedings before the court. However, it is not necessarily so. In particular, being a witness before the courts is on a voluntary basis, so victims cannot be forced to be witnesses.
The rights of the defense in general are protected throughout the entire pre-trial process. So if we come to the stage that we're approaching now, which is the confirmation of charges, this is not something unique in itself, meaning that every single part of the process, the rights of the defense are taken care of. In any ruling the chamber is engaged into, the rights of the defense are always balanced and weighed. Throughout the entire proceedings, you have the rights of the defense are always taken into account and protected. And those rights are mainly reflected in Article 67 of the Rome Statute. When it comes to the process of the confirmation of charges hearing, of course, one of those rights that the person has to be heard. Hearing should be done without undue delay, that he could question witnesses. All of those rights, as I said, that are mentioned in Article 67 of the statute. And the biggest right at the end of the day is the decision that's going to be issued by the judges weighing the entire evidence presented at the end of this entire process. That's what actually could guarantee the ultimate right of the defense. Because if judges have decided not to confirm the charges and to commit the person to trial, that's the biggest achievement that the suspect would get.
So at the end of the confirmation of charges hearing, the judges have different options. First of all, it must be understood that this is the determination of the judges. What the prosecutor has proposed in his document containing the charges is a proposal for the judges. The decision at the end is solely in the hands of the judges. They can first decide to commit the person to trial. And this decision makes the scope of the trial. It means that the person will be committed to trial on the basis of the charges as confirmed by the pretrial chamber. The basis for the trial is therefore not the document containing the charges, but the decision of the pretrial chamber. This decision could also be not to confirm the charges. And I need here to make it clear that there could be a combination of confirmation and not confirmation. This combination could be a combination, I would say, according to the people. Out of the 6 persons which are charged by Luis Moreno Ocampo, only 2, 3, or 4, for example, could be sent to trial, and not the others. This could be also according to the charges. Those persons could be committed trial only on some of the charges presented by the prosecutor, but not all of them. If the chamber decides not to confirm the charges, this is not really the end of the matter. It's the end of the prosecution for the moment. This does not preclude the prosecutor, under Article 61, paragraph 8 of the Rome Statute, to come back with new evidence and ask again the confirmation of charges against the person for whom the chamber has decided not to confirm the charges. There is a third option, which could be either to say, Mr. Prosecutor, the judges think that you need either to provide more evidence or to conduct further investigation. And then actually, the chamber is not going to decide now on whether to confirm or not, but will adjourn the hearing, go back to the prosecutor, and request him to present more evidence or conduct further investigation. A last option is simply that the chamber is going to say, I have enough evidence to confirm charges, but I disagree with the way the prosecutor has presented the charges. I think that actually the crimes presented are not the good ones. I don't think this is this crime, but it should be another crime. Then the chamber will also adjourn, go back to the prosecutor, and ask him to modify the document containing the charges. At the end of the confirmation of charges hearing, the chamber has, according to Regulation 53, 60 days to issue its decision. First of all, this can start either starting by the last day of the confirmation of charges hearing, or if the judges grant the possibility to parties and participants to present written observations, from the last day of the last written submissions. Finally, I think it has to be understood that this is a deadline in the regulations of the court, and it can be changed if, according to Regulation 35 of the regulations of the court, good cause is shown. So if there is a reason for the judges to change this 60 days deadline, they can do so.